Good evening to the students of the International Human Rights Law. Karibu sana. Welcome to the today class. And it is a review class is going on over there, and where we are to discussing the cases. Because generally that I told you that the pattern of the examination, the first question would be the problem question, which is a compulsory and whose marks are 40. And the second question is the analytical based question, and I give the statement and I will say that whether you justify your answer with the suitable cases, whether you agree to the proposition or not, whether you agree to the statement or not, and answer your justify your answer. That is the second question. And third question I told you either is a problem based question or the directly case law based one, and where you have to attempt it in the PFIRAC model. And the fourth question is in essay type question, and it can be covered the entire syllabus and what I taught you in the class and what I made you to read, and we discussed it. That is the fourth question. And the last question, the fifth question, is the short bit answer questions, and I'll give you the 4. Out of the 4, you have to do the attempt only 2. So all questions carry equal marks except the first question whose marks are 40. The rest of the 2 questions you have to do is 30 plus 30, 60, 60 plus 40. Compulsory question, and it becomes a 100 marks question, and the duration of the time is 3 hours, and you should be fast enough to write it, and don't write a very lengthy answers. Try to be short and give the reason for that one, and that will be the quite good. Yes, now what I posted on the screen, any participants could unmute and read what I posted on the screen. And the screen I posted: good evening to the students of the International Human Rights Law, Karibu sana. Then I put the co-host, the Professor Dr. Mohammed Saheb Hussain, Professor Law, South Manza, Tanzania, East Africa. Yes, in there I put it on the screen, the globe, and having all the flags of the different countries. And I told you that how many countries are there now at present. If I'm not mistaken, it's 193 to 194, but 3 countries are only observed. Still, they did not make it out. Another point in the image we could see where the cursor is there. What is this one like hammer, and what is the here? Anyone can unmute and give me the answer. And here it is called a sound plug. The chini, the down one is called, and this is the like hammer. The excuse me, it is a gavel, G-A-V-E-L, gavel, we will say. I repeat, G-A-V-E-L, gavel. This is the hammer type 1, wooden one, and it is called the sound block or sound plug. These are things we can say. Now, without wasting the time, we will go to our point of study is concerned. Yes, I told you that we are going to study today the cases, how yes, where I put it, the cases. Oh, no, this is not the file. Okay, now it is here. IHRL, yeah. And here the African Commission for the Human and People's Right, we have made it Almas Muhammad. This is the case law. And the Chacha case law is important case law, and you have to write in the PFIRAC model and Iraq model. And here I am showing you the cover page, what would be the content of it, which I told you already. So that we have to keep it in your mind, the content, how it would be. And then we come to the ECHR. No, we will deal with one of the case law. So, yeah, I gave the cases, you have to study it, but I don't know how many people are studied it. And are you hearing me? The participants, International Human Rights Law participants, are you hearing me? See, I told you that please attend the classes so that it will be the good for you to face the good marks. So sample questions I already given you. Let me do one of the cases, Rajabu Yousuph case law we will see today. How it looks. Rajabu Yousuph case law. So in the matter of the Rajabu Yousuph versus United Republic of Tanzania, and the application number 036/2017, And the parties, it is clearly mentioned, subject of the applications, facts of the matter, alleged violations, summary of the procedure before the court, and prayers of the parties, jurisdictions, and cost and operative part. Now let us see that what is the case law it is. So it is the Rajabu Yousuph versus self-represented and the United Republic of Tanzania, and there the represented by the many people from on behalf of the Tanzania and the Solicitor General, Director, Attorney, State Attorney, Principal State Attorney, Director Legal Affairs, then Assistant Director, Division of the Constitutional Affairs and Human Rights, Senior State Attorney, and the Ministry of the Foreign Affairs. These are the parties, the opposite parties. We can say respondent state. And let us see the parties, what they are parties. Rajabu Yousuph, and hereinafter referred as the applicant. He's a direct applicant. He's a national of the Tanzania. When you say at the time of the filing, the application was at Uyuyu Central Prison. He is there, Tabora. Uyuyu Central Prison, Tabora region, serving a sentence of life imprisonment, having been convicted of the offense of rape of a 6 years old minor. How could a person will do a rape to the 6-year-old minor? And he challenges the circumstance of this trial, his trial. So the application is filed against the United Republic of Tanzania, and here we refer as the respondent state, and which became a party to the African Charter on the Human and People's Right, and here referred to as the Charter on 21st October 1986, and to the protocol on 10th February 2006, the respondent state on 29th March 2010 deposited the declaration prescribed under the Article 34, Class 6 of the protocol, here after referred to as the declaration, through it accept the jurisdiction of the court to receive the application from the individuals or the non-governmental organizations, or the Human Rights Commission also will file a case. And here, the respondent state deposited with the chairperson of the African Union Commission and an instrument withdrawing the declaration. The court held that the withdrawal has no bearing or pending cases, and a new case filed before the withdrawal came into the effect, that is 22nd November 2020. So now we'll see what is the subject of the application. The facts of the matter is, it emerged from the record from the court that the applicant, means Yousuph, and Rajabu Yousuph, the applicant, was arrested because of the charge before the district court of the Tabora in criminal case number 112/2005 with the offense of rape of 6 years old minor. So he made an offense of the 6-year-old minor. It is the sexual abuse of the minor, and hence it comes under the violation of the human rights. The applicant was convicted and sentenced to serve the life imprisonment on 1st November 2005. So Tabora District Court has given the judgment that the perpetrator and who it is proved that he is convicted and sentenced to life imprisonment by the Tabora Court, District Court. The applicant filed an appeal before the High Court of Tabora, and the High Court was sit over there in some places, and being a criminal appeal of the 31/2006 and 2005 judgment is given, and he appealed in the 2006, 31st and 27 June 2007, this appeal was dismissed. So High Court appeal also dismissed over there. That means the High Court upheld the decision of the District of Tabora Court. So the fifth round point is, the applicant filed a further appeal to the Court of Appeal. So from the High Court, because in our discussion, I told you that first exhaust the local remedies. Once you exhaust the local remedies, then you can approach to the higher court. Up to that extent, you are not supposed to go for the higher court. So that is the first district court has given the conviction, and he challenged on the judgment of the Tabora District Court, and he filed a case in the High Court of Tabara. High Court Tabara convicted him, upheld the decision of the district court, agreed by that one, and he appealed to the last resort Court of Appeal of Tanzania. So there the Court of Appeal of Tanzania, sitting at Tabora at the time, being criminal appeal number 457 by 2005, and its judgment of the 28 October 2009, after 4 years the judgment is given by the Court of Appeal. The Court of Appeal dismissed the appeal in the entirely, and the applicant was ordered to pay the compensation. And there they say Court of Appeal dismissed his appeal, this appeal in its entirely, and the applicant was ordered to pay the compensation to the victim, and amounting to 100,000 millions, 1,000 shillings, 100,000 shillings he had to pay as a compensation. 100,000 shillings he has to pay for the compensation. So that was the decision is given over there by the Court of Appeal. To the whom he approached to the, yes, he approached to the High Court, and the High Court also, are you hearing me? Yes. Are you hearing me? Say, are you hearing me? Say yes, so that I continue. Okay. Now let us see that in the Court of Appeal also confirmed it and ordered the applicant to pay the compensation 100,000 Tanzania shillings to the victim. So that was the decision given by the Court of Appeal. Then now let us see the alleged violations are there. The applicant alleges that the respondent state violated his rights, notably, number one, the right to equality before the law and equal protection of the law protected by the Article 3, Class 1 and Class 2 of the Charter. Number two, the right to have his cause heard protected under the Article 7, Class 1 of the Charter. Then the third one is the right to legal representation protected by the Article 10, Class 2 of the Protocol of the African Charter and the Section 2 of the Child and the Young Offenders Act, that the Cap 13 Revised Edition 2002. Now let us see the summary of the procedure before the court. The application was filed. Of course, we are not that much worried about the date when it is filed over there, but what is the outcome is there that is more important to us. The parties filed the pleadings on the merits and reparations means damages within the time stipulated by the court. Pleadings were closed by 23rd July 2019 and the parties were duly notified. What the prayers of the parties are, the applicant prays that court to restore the justice before it was overlooked, quash both the convictions and the sentence of life imprisonment imposed upon him and order him release from the prison. He further prays that the court to grant any other orders that may be appropriate or deems fit to the court. In its response regarding the court's jurisdiction and admissibility of the application, the respondent state prays court to order the following. The respondent also make the following request, order and prays that the Honorable African Court on Human and People's Right is not vested with the jurisdiction to adjudicate to this application. They made a strong preliminary objection that the court doesn't have the jurisdiction to entertain such a case. Number two, that the application has not met the admissibility requirement stipulated under Rule 45 of the rules of the court. So admissibility of the case is not strictly followed as per the norms, the court rules of the court. That is a charge at the prayer they made by the state, means respondent state, that the application has not met the admissibility as per the rules of the court. The fourth one is that the application must be declared inadmissible. You should not be admitted over there. That the application may be dismissed. That is the contention of the appellant state. Respondent state. With regard to the merits of the application, the respondent state praised the court the order of the following measures, and they requested that these orders should be made. Did not violate the application right provided in Article 2 of the African Charter and the People's Right. And then the United Republic of Tanzania did not violate the application right provided in Article 3, Class 1, 2 of the African Charter on the Human and People's Right. Then the Government of Government of United Republic of Tanzania did not violate the applicant's right provided under the Article 7, Class 1 of the African Charter, because all the things were made by the applicant, and the respondent state is denying it. The Government of the United Republic of Tanzania did not violate the applicant's right provided by the Article 7, 1C of the African Charter on the Human and People's Right. And the Government of United Republic of Tanzania did not violate the applicant's right provided Article 107, capital A, Class 2, small b of the Constitution of the United Republic of Tanzania, 1977, or as amended time to time. And the sixth point is that the applicant be dismissed in its entirely for the lack of merit. And the seventh point prays that the applicant prayers be denied. And the last point is that the applicant be ordered to pay the cost of this application also. Of course, jurisdiction it is having over there, and hence it is entertained. And objection to the material jurisdiction, the respondent state raises the three objections in respect of the court's material jurisdiction. And the firstly, material jurisdiction they discussed, and the secondly also the material jurisdiction, and third also the respondent state argues that the court is not vested with the jurisdiction to adjudicate on this matter because the present application calls for the court to sit as an appellate court and adjudicate on the matter of the and evidence already finalized by the respondent state's highest court, the Court of Appeal of the Tanzania. And hence, citing the court's jurisdictions and Ernest Francis Mitingvi versus Malawi, that is one of the case law which you made it over there. And the respondent state claims that the court does not have any appellate jurisdiction to receive and consider the appeals in respect of cases already decided of the domestic national courts. And I told you yesterday, and I sent the WhatsApp group also. Today, I sent some of the cases to you, and I thought that you would come and present the case law, but here nobody has. Just I found the Malibu was present later on, and Webex meeting error has occurred. Okay, that is a matatizo over there, but no matatizo from my side because it is recording and it is. Yeah, you could hear my sound. So, yes, sometimes, no, the sound is coming. Yes, I could see over here. Because when I speak, it is palpitate. That means you could hear me. And if you don't hear me, then the matatizo will be differently. And moreover, today class is a physical class. And I already told you, if you want, I can make the physical class also. But nobody has responded for my things, timetable which I have given you. And I told you that I would make the revision. The revision is very much important factor. Yes, because it is coming and going. The palpitation is there, the green signals. But I don't know what is the problem with your phone. Because here I shared the file also. And the file also visible over here. And my recording is going on as it is. And once I recorded it, again I will load it and you can hear that. And Malibu was present, at least try now, whether you can join it or not. Again, the same thing is showing. Raman, you log in, when a problem comes over there, you log out, again you log in. At that instance, you could come and inform the same thing to Malibu also. because the mode you chosen it, because the mode of teaching, otherwise only one in a day, that is a Friday, the entire 3 classes will be conducted. So instead of that thing, that I made this arrangement so that if any person misses also, he could hear the classes. So that was my contention. So again, you try to join it, log out and log in, because the signals are very weak, very not good, because I used the hotspot just before when I was teaching to the Indian students, those who are aspirants for the postgraduate law set exam conducted with the Osmania University. When the net is out, then I use my hotspot. Then hotspot, it worked well, and they heard it and they responded it also. Yes, try to log in, because I could not see that. Again, the same perturbed over there. Webex meeting error has occurred on the server. Contact technical support. Error code. Send log file Cisco Webex. Cancel or report. Let me see that whether it is my... Now it is recorded or not, it will be seen to me also. Because when it is recorded over there, then naturally it will come. You do one thing. You completely, what I say, power off, again power on. Power off and again power on. Because here it is showing very clearly. Yes, when I speak, it will come. When I don't speak, it will disappear. That the microphone. So you do one thing that the same way. So in the final, what is happened in this Yousuph-Rajabu case, Union Republic of Tanzania, objection to the temporal jurisdiction. Of course, we discussed temporal jurisdiction, material jurisdiction, pecuniary jurisdiction, and territorial jurisdiction. Even Masanja also, Thomas Masanja, and he also made very much clear the jurisdiction, because earlier we did not know such jurisdictions. But anyway, they will touch all the jurisdiction and then only they will entertain the case. If not, they will dismiss the case. Who? African court. So there are many jurisdictions, they will come, it is attracted, then the admissibility was there. And pursuant to the Article 6.2 of the protocol, the court shall rule on the admissibility of the cases, taking into account the provision of the Article 56 of the Charter. That is the reason they admitted it. Then question comes to the objection to the admissibility of the application. The respondent state, that means the Union Republic of Tanzania, raised 2 objections to the admissibility of the application. The first objection relates to the requirement of the exhaustion of the local remedies. Yes, he approached the district Tabora court, and the Tabora court convicted it. Again, he approached the High Court in Tabora. It is upheld the decision of the district court. Again, agreed by that one. He appealed to the Court of Appeal. Court of Appeal of Tabora also dismissed the appeal, and they said compensation to be paid to the victim, that is 100,000 Tanzania shillings. So objection based on the non-exhaustion of the local remedies. No, he has exhausted. The respondent state argued that the applicant is raising before the court 2 allegations which were never raised before the Court of Appeal in Tanzania. But overall, what is the judgment is given. The respondent state submit that since the applicant did not pursue these remedies that are available to him and there were no delay in accessing them, the application not met the admissibility requirement under the Rule 45 of the rules, the protocol rules. But anyway, the case is admitted, the decision also given. The applicant therefore claims that the fully exhausted all the available local remedies, because the first case he filed in the district court of Tabora, and the Tabora is convicted him, then agreed by the decision of the Tabora district court. Then he approached the High Court of Tabora. High Court Tabora confirmed the district court decision, and again he went to appeal to the Court of Appeal of Tabora. Court of Appeal of Tabora dismissed the case and asked the pay to the compensation, victim to the compensation. That means all the local remedies are exhausted. In that instant case, the court notes that the applicant appealed before the Court of Appeal, the highest judicial organ of the respondent state, was determined when the court rendered the judgment on 28th October 2009. Therefore, the respondent state had the opportunity to address the violation alleged by the applicant arising from the applicant trial and the appeals. So, objection based on the failure to the application within a reasonable time, they made it over there. Then the question comes in the last manner, what is the court judgment? We will see it. Because these are all the arguments, we need not to remember it, nor the dates we should remember it. What is the principles laid over there, and what are the at least 2 or 3 sections are violated under the charter or under the protocol, you have to remember it. At least 2 sections or two articles are, because for international instruments we'll say articles, we don't say sections. So now the court further note the applicants, the applicants is concerned for the court's docket, that court docket, which will be there on the face, they could write it the stages, what will happen, the different timings. The application originating from the UU prison. I don't know how you pronounce. Raymond, how do you pronounce UYUI? UYUI prison in Tabora. So, not continuity. UYUI prison. UUI prison in Tabora, and was filed 4 months and 26 days. The UUI prison. And there they cited Abdullah Saspiter, Moamba, and others for say United Republic of Tanzania also. So if you go further, the instant case, although the applicant was at the material time incarcerated because he was put behind the UUE prison, and he has not provided the court with the compelling arguments and sufficient evidence to demonstrate his personal situation and prevented him from filing the application in more timely manner. So other condition of the admissibility is having found that the application was not satisfied the requirement of the rule. Of course, you cannot remember all the rules. Just you can write it in your examination. The requirement of the rule is not satisfied over there. That is the contention of him, and the applicant contention that he satisfied it. Because of the satisfied manner only that the case is admitted. When the case is admitted, whether he won the case, if he lost the case, we will see it now. Though now the question comes, other condition of admissibility, they said, having found the application has not satisfied the requirement of the rules, the court need not to rule on that application compliance. Of course, they made the compliance rules of 52A, B, C, D. We cannot remember all those things, but we can generally say that rules were not followed over there in that particular case. So now cost, the applicant did not make any submission on cost. The respondent state prayed that the cost be borne by the appellant, and pursuant to the rule 32 of the rules of the court, unless otherwise decided by the court, each part shall bear its own cost. So, of course, the respondent state wants the cost should be paid, and the applicant did not make such a thing. So the court decided that let the party shall bear its own cost. So the court finds that this is nothing in the instant case warranting it to depart from the provisions, and consequently the court ordered that each party shall bear its own cost. The operative party is it. For this reason, the court unanimously on jurisdiction dismisses the objection to the material jurisdiction, dismisses the objection to the temporal jurisdiction, declares that it has a jurisdiction in the admissibility is concerned on jurisdiction. And admissibility, again, the fourth point, dismiss the objection based by the non-exhaustion of the local remedies. No, the exhaustion of the local remedies by the majority of the 9 for 1 against Justice Chafika Bensoula, and finds that the application was not filed within a reasonable time with the meaning of the Article 56, subclass 6 of the Charter. Of course, we can say that it is not fulfilled the condition on the articles and the Charter rules, and declares that the application is inadmissible. On cost, order each party to bear its own cost. So, the application is inadmissible in overall, and the case is not made. In other sense, the United Republic of Tanzania stand is high over there. The conviction is conviction, and it's not made it over by the court. That is the reason declared that the application is inadmissible. Here the application is made by the Rajabu Yousuph. But where it is clearly mentioned that he made a rape to the 6-year-old girl in Tabora. So it is an inhuman activity, and such thing that no court or no public will encourage such a thing. And when the perpetrator is done a particular thing where it is proved that hence he should be punished as per the law is concerned. So that is the Rajabu Yousuph case law where we can make it out and feel it. So now the question comes over there. If you make the revision, you will remember the things. If you don't make the revision, and there is a probability that you will lose many points over there. That's why I told you, let me make the revision of the cases, because cases are very important factor that we did not discuss in our regular classes, but we are discussing now. Yes, the only the thing is now, the African Charter, they violated it, and protocol, they violated it, and hence admissibility is there, inadmissibility is there, will be taken consideration. Of course, the respondent state also will make it out on what way that he can admit it, because there is no injustice caused over there. And whether he did the rape or not, it is very much clearly proved that he did the rape. When he did the rape over there for the 6-year-old girl, then why he wants to approach to the court that injustice has happened to me and I was incarcerated, I was put behind the bar. Yes, when the court has decided that life imprisonment, yes, he should be there behind the bar. But an opportunity will be given to the applicant, even to the approach to the court, the African court also. But the African court has made it very much clear that the appeal is inadmissible. That means he should have to be undergo the life imprisonment. So that is the case where we can make it out. So I have sent the cases to you, the list of the cases, it will be allowed in the examination hall. I say list of the cases, but not the case law, total case law. I did not say the total case law. I said list of the cases will be allowed in the examination hall. So list of the cases in the bare acts, if you want to make it out, Charter bare act, if you want to make, yes, you can be allowed. But to my knowledge, better not to take anything, because in surfing or in the turning the pages, you lose your time. Better if you could sure about at least one article or one section. Of course, municipal law that you are supposed to cite it, because we are not following the other law, if it is municipal. But if we are following the international instruments are concerned, yes, we have to know it on what basis protocol the case is admitted, or what is the violation of the charter is made. Because here they made, in the use of Joseph case law, that is 56 they used it. If I not Rajabu Yousuph case law, at least 2 or 3 articles that you have to remember it when you want to cite in the examination. But if you don't cite at least 1 or 2 articles, if you say merely there is a violation of the African Charter is there, after Charter is having only the 30 to 40, at least remember one case and you can cite it there. That will be good for fetching the marks. So now, at least could you open any one of the case law now on your phone? Because if you speak, it will catch it. It will catch it automatically. If you speak from there, it will catch it. And from there only you can speak, and you present the case law, it will catch it. Anyone that, because I sent at least 12 or 11 cases. No, 12 cases, 2 cases man, 14 cases I sent. And they made it the name. Under your name, what are the cases are there? Read. Imbele. You pull the chair near to them.
4 cases.
Yes.
The first case is Alimas Mohammed Muwinda, and the others are with the United Republic of Tanzania.
Okay.
The second case is the African Commission on Human and People's Rights, versus Republic of Kenya. The third case is Anudo Cheng Anudo versus United Republic of Tanzania.
Okay.
And the fourth is Harold Mbalada Mthali.
Harald Malambada Muntali.
Yes.
Versus?
Republic of Malawi.
Yes. So which case that you read today? And you are going to participate or present it?
Actually, I've gone a little bit on the first case.
Okay, you make the...
Yes.
You tell me who are the parties in the first case?
In the first case, the parties are Alimas Mohammed Muwinda.
Okay.
And the others versus United Republic of Tanzania.
Okay.
Yes, in this case, Alimas and 52 others were the employee of Urafik textile industry.
Very nice.
Now they filed a case to the African Court on Human and People's Rights against the Republic of Tanzania as a responding state.
Okay.
The main issue in this case are the applicant we are alleging that the responding state has violated their right to work against the African Charter on Human and People's Rights.
Very nice.
But as well as the Tanzanian Constitution.
Okay.
But also, the applicant were alleging that the responding state has violated against non-discrimination.
Okay.
The right against non-discrimination as provided by the African Charter on Human and People's Rights and Tanzania.
Is it a non-discrimination or discrimination?
Non-discrimination.
Is it written clearly? Check it. Is a non-discrimination means they are treating well. Discrimination they are making means changing it.
Yes, actually. Yeah. So they filed a case to the African court alleging on those two main issues.
Okay.
So their prayer to the African court was that they have to be paid a allowance. Allowance or compensation. And the court made it clear that the responding state did not violate any article of the charter or any article of the constitution of Tanzania. Okay. So the case was dismissed on the favor of the responding state.
Did they use any labor laws in that employer-employee labor laws?
The applicant?
Oh.
Yes.
So what act they used? Which act they used in the labor law?
The act which they used in the labor law. Actually, I did not go through that. Yes. I don't remember it actually. Yeah, I don't remember it.
Because they did not challenge on the labor laws, but they challenged on the articles of the Constitution and article of the African
Charter.
African Court, the Human Rights and Human and People's Rights Charter.
Yes, yes.
On the basis of that one, they made it out. Whether these people has approached to the district court to the labor court to the tribunal to the high court to the court of appeal.
The first court of instance was the high court.
Okay.
Yes. Now the high court find out that there was no any violation.
Okay.
Yes. Then the applicant were not satisfied. They appealed to the
Court of Appeal
of Tanzania. Then the same...
The Court of Appeal of Tanzania of Dar es Salaam or Tabora or Arusha?
Of Dar es Salaam.
Yes, sir.
Yes. And then the Court of Appeal of Tanzania ruled the same as the High Court of Tanzania.
Upheld the decision of the High Court.
Oh, yes. Now,
then, agreed by the decision of the Court of Appeal.
Yes. Now they went to
the applicant appealed to the African Court. But the African Court also, by going through all it, the appeal is dismissed.
Yes.
Is it?
Yes. The appeal was dismissed.
Because there is no violation of any charter.
Yes.
African Charter, nor there is a violation of the Constitution of Tanzania. So that would be the case. See that when you have a problem, you can call me and notify me because I speak with the laptop. And when you call me, I can speak also with my phone. So when a problem would be there, you can, of course, I can also make it out whether the problem is there or not. Because when the problem is there is no palpitation here. See, I am not speaking. It will go away now.
Time is up.
Yeah. So when I speak, it will palpitate. If I don't speak, it will not palpitate. But cursor should not be there. If the cursor is there, it will not work. And signals are clear here because I could see the signals. There is no problem of signals. So that will give the sense that my voice is reaching to you. Because when I don't speak, it will go away. When I speak, it will palpitate. The microphone will come in the green light. So that gives the sense to me that, yes, there are still 5 minutes are left. Still there is the 5 minutes are left over there. And you can say, because any question paper, it should be framed with all type of questions should be there. Problem question should be there. Analytical synthesis question would be there. And case law based question is there. Plus essay type question is there. Plus short question answers are there. But you cannot, there are 5 types of the question because some are good in analysis, some are good in the case law, some are good in the problem solving, and some are good in the short question answers. So when you want to cover the entire syllabus cannot be covered in the 3 questions because there are 5 units or 6 units are there. In some subject there are 8 units are there. The 8 units, when you want to cover it, at least in the short questions, we can cover the 4 units. And for the long questions, we cover the 3 units. So 7 units or 8 units we can cover in it. Otherwise, we cannot cover the entire syllabus and frame the question paper. So a question paper should be consisting of that one. And each question should be moderated. And there should be a moderator would be there and he will give the comment. Yes, question should be in this manner. Question should be in this manner. Otherwise, if you give your own choice question, it cannot be done. And there should be a uniformity in the question pattern. If for instance, the school of law, there is a uniformity should be there. And one lecturer could not ask the question, second question is a compulsory question. Hapana. The second question is based on synthesis or based on analytical, critical study with your statement. Whether you agree to the statement or you disagree. If you agree to the statement, what is your face value? If you disagree to the statement, what are the grounds for it? Our third question, again, either frame it a problem question or directly case law based. Because that's the reason that I have given the cases to you. At least 12 cases. And the 12 cases, if you read it, no, I'm sure that that's the same cases you can use in other questions also. Because it is nothing but human rights violation. So that will be the very good point. And hence, at least 4 into 3, 12 cases, if you discuss on the online class, you will remember the things. When you remember the things, in the exam, you can reel out. Oh, we discussed this. Mohammed said, this point should be given over there. Mohammed said, you could not remember all the sections or the articles of the charter. At least 1 or 2 you remember. Protocol 1 and charter 1. That will fetch you good marks. But if you don't write that, there is no violation of the Human Rights Charter. No. You will get the less marks. At least cite 1 or 2. What is the violations are there? Under the Charter or under the Constitution? Under the protocol. Whether admissibility is there or not, protocol will say. Whether the law of limitation will work over there or not, protocol will say.
May I ask you?
Yes.
you have given us more than 10 cases.
Yes.
Each of us has 3 cases.
4 cases.
Yeah, 4 cases.
If you present the 4 cases, other people will hear it. Even they do have the knowledge. And they present it and you have the knowledge. So it will be the exchange.
Now, I'd like to know in the exam paper, there is a question of, I think, which concerning with cases. Now, I need to know on those questions, we shall be answering those questions regarding to this case which will be given us. Or
If the case law will be given, you have to do in the PFIRAC model. PFIRAC model, case law is given. Suppose if a problem question is given, it should be followed in the Iraq model. When you are answering problem question should be in Iraq model and the case law based question is in PFIRAC model. So that you close this one, close this one. Close this. There will be less sound. Okay. So based on the questions, you have to essay type question, you need not to follow the PFIRAC model, nor Iraq model.
So I spend a lot of time working on social media for my clients. I create a lot of video content